Good evening. On behalf of the Carbondale Branch NAACP, welcome to our second monthly community conversations around voting and election issues. Tonight, our presenter is Dr. Linda Renee Baker, who has been with the Paul Simon Public Policy Institute since 2003 after stepping down from her position as the Secretary of Illinois' largest state agency, the Department of Human Services. This evening, we will be discussing the topic of the 1964 and 1965 Voting Rights Act, as well as the voting rights legislation that is currently stalled in the Congress, as well as why there is even a need for such legislation. This evening, our Q&A will be handled by Carbondale Branch NAACP Life member, Dr. Ella Lacey, who is also our Health Committee co-chair. If you have any questions, we ask that you will put them in the Q&A or the chat section at the bottom of your screen. And now, please join me in welcoming Dr. Baker.
Good evening, everyone, and thank you very much for that warm introduction. I'm Linda Baker with the Paul Simon Public Policy Institute at Southern Illinois University at Carbondale. And today we're going to talk about a very interesting topic, the issue of voting rights. The Voting Rights Act of 1964 and 1965, and what's on the horizon today. When we think about the Voting Rights Act, looking back to 1964 and 1965, there was a pamphlet that I looked up, and the pamphlet really talked about what colored men should do to vote. That circular was sent around the South as individuals thought about and talked about how African-American or colored men could vote after the Civil War. The 14th Amendment to the Constitution of 1886 actually granted African-Americans citizenship. Rights were given to African Americans, and those rights were really around citizenship. However, those rights that were given did not translate into the ability for Black individuals to vote, neither male nor female. Blacks were systematically turned away from state polling places throughout the South, and the problem was combated by the fact that Congress passed the 15th Amendment in 1870. And that 15th Amendment in 1870 said that the citizens of the United States shall vote, and vote should not be denied or abridged by the United States or any other state on the account of race, color, or conditions of servitude. However, states found a way to circumvent that constitutional requirement, and they prevented Blacks from voting by such measures as polling tax and literacy tests, things like intimidation. Dogs were brought out, and African Americans were turned away from the polls until the Supreme Court came down in 1915, and many states used such things as grandfather clauses, and individuals had to show that they had a grandfather before them that voted in order to vote, to keep descendants of slaves out of the elections process. This clause caused many to stay away because it was impossible for descendants of slaves to have ancestors that had voted before them. These practices were unfair, and they were debated in the streets across America, and it was debated in the Congress. For a full 50 years, even after the 15th Amendment passed, Blacks were still in the predicament where they found it difficult to vote, especially in the South. There were many posters and billboards that moved around town, and there were a list of things that Blacks had to do in order to vote. And most of those things on the list, Blacks during that time could not do. The aforementioned ideas and practices around voting rights were real. And at the backdrop of 1965, the Voting Rights Amendment, it was clear that even after the amendments were ratified from the 15th Amendment was ratified after Reconstruction, it brought to light that there were measures that were being taken, again, such as the literacy test and poll tax and grandfather clauses that barred Blacks from voting at the polls. Individuals knew that something had to be done. So there was a promise of a new day as African Americans in the South started to look and think about ways to vote and what they could do to get engaged and involved in the voting process. And there was much sweat and tears that were shed and blood that was shed across the South as individuals worked for and fought for the right to vote. Well, it was on August 6, 1965, when then President Lyndon Johnson signed what we know today as the Voting Rights Laws. And during that day, they called it a triumph for freedom. It was a huge victory. It was a victory that had never been won before. And when you look at some of the things that Johnson said as he stood in the Capitol Rotunda, he said the law came 7 months after Martin Luther King launched the Southern Christian Leadership Conference in Selma, Alabama, with the aim to push Congress to pass legislation, not just for the South, but for the United States, certainly starting in the South, to make sure that voting rights were available to all individuals, especially that Blacks were able to be brought into the fold. In Selma, King wrote, "We see a classic pattern of disfranchisement typical of the Southern Black Belt area, where the Negroes are in the majority." And in Selma, King said, "The shame of the promise." In addition to facing arbitrary literacy tests and poll tests, African Americans in Selma and other Southern towns, they were intimidated, they were harassed, they were assaulted, and they were sought after. They were run away because they wanted the right to register to vote. Civil rights activists met with fierce resistance to their campaign, and it attracted not only the attention of those in the South, but it attracted national attention. So on March 7th, 1965, when the civil rights workers were brutally attacked by white law enforcement officers on a march in Selma, Montgomery. This promise of a new day, this Voting Rights Act that was supposed to bring a promise, when Johnson introduced that Voting Rights Act the same month with outrage about what had happened in Selma, and it was still fresh on the minds of many. In just over 4 months, Congress passed a bill, the Voting Rights Act of '65, and that act was designed to abolish all of those literacy tests and poll tests. And it was designed to really deal with the issue of Blacks and African Americans being disenfranchised as voters. And it gave federal authority, not just state authority in one state, but it gave the federal government the authority to take over the voter registration in the counties with a platform that had been persistent with discrimination. And the law covered many pages, and it was not a short bill. It was a law that covered many pages. And Johnson said before he signed that act, he said, "But the heart of this act is clear and is plain. Whenever by clear and objective standards, states and counties are using regulations or laws or tests to deny the right to vote, then they should be struck down." And he said that as he talked about the Voting Rights Act. And as we look at some of the things that Johnson said when he spoke, he spoke boldly and he spoke loudly. And as he took pen to paper, he meant for the freedoms and the rights of individuals unapologetically. Those individuals that were individuals of color, Black individuals in the South, Black individuals across the country, that there should no longer be a practice where they were denied the right to vote. Next slide. So on that same day that Johnson signed the bill and he penned the letter that I shared before you, he announced that his Attorney General then, Nicholas Katchenbach, would also initiate a lawsuit. And this was one of those landmark cases against not one, not two, but 3 states that were still, even though the laws had changed, those states were still requiring a poll tax in order for individuals to vote. And individuals, those individuals, it was not white individuals that were required to pay that poll tax. It was clearly Black individuals that were required to pay the poll tax. And so in those 4 states that required the poll tax, the lawsuit was initiated. And although King called the law a great step forward in removing all of the remaining obstacles to the right to vote, he knew that the ballot would only be an effective tool for social change only if voters would rid themselves of the fear that was associated with voting. And that was King in 1965. And he said this was done with the goal of ridding Americans of political racism and fear that moved around the South during this era as individual Blacks were trying to gain the right to vote. Even though the Voting Rights Act of 1965 was passed and the measure was ratified by Congress, the fight still continues. And so today there are pieces of legislation that are moving through Congress, and we know that many of those pieces have been stalled. One is named for the late Representative John Lewis, civil rights icon who died in 2020. And that act would restore part of the landmark Voting Registration Act. And that's called the Freedom Act, which is historic legislation that's designed to strengthen American democracy, promote racial justice and equality for all Americans, and making sure that rights are protected, not only in one state, but across the country. As we look ahead, the John Lewis Voting Rights Act, again, designed to restore and update full protections of the Voting Rights Act, and then the Freedom to Vote Act. In the wake of the 2020 election, an unprecedented wave of restrictive laws came across not only the state of Illinois, but across the country. And many individuals talked about election sabotage, and efforts were taking hold in many states, and more are likely to be on the horizon in the coming years. And when we think about the things that happened, such as partisanship and gerrymandering, not only the gerrymandering within a political party, one Republican versus Democrat, but also gerrymandering within the respective parties, where oftentimes communities of color are cut up, and they're cut up where you have individuals that live in one district, and then they may even have to move from their district because the political lines are drawn in such a fashion. So both of these attacks on democracy is really have been an attack on communities of color. And so Congress has the legal and constitutional power to actually pass legislation. And one of those pieces of legislation is called the Freedom to Vote Act. And it's an act that would set national standards, not state standards, but national standards to protect the freedom to vote. It would counter election sabotage and partisanship, and would also deal with the issues of redistricting, and really looking at also fixing some of the campaign systems, because when we think about voting rights, we have to think about who can vote, and we have to think about elections and how much money is actually spent during the election process. And the John Lewis Voting Rights Advancement Act, as I said earlier, is designed to actually restore, and not only restore, but to update the full protections of the Voting Rights Act, as well as the Freedom Act. And those two pieces of legislation will be comprehensive, along with the redistricting that's well underway now in 2020 as we lead into the midterm elections. And it certainly has been delayed in Congress. We've seen many states talk about, as such as us here in Illinois, we're talking about passing those pieces of legislation now, but they have been stalled for a multitude of reasons, and many of those are political in terms of why they have been stalled at the congressional level. The efforts have been made to pass those pieces of legislation, but they have actually been stalled. Next slide, please. Okay. As we think about the pieces of legislation that are on the horizon right now, with regard to the John Lewis Act and the Freedom Act, we also know that there are some opportunities. And when we think about what those opportunities are, one is expanding the opportunity to vote. Some of the things that have been done are things such as early voting. And if the Freedom Act passed, early voting is done in some states, but we know that there are many states that do not allow early voting. But if the Freedom Act passed, this bill would require all 50 states to offer early voting for a period of at least 2 weeks prior to Election Day, including nights as well as weekends, and for at least 10 hours per day, except for jurisdictions where there are less than 3,000 people. And each state would be required to ensure that it was possible for individuals to vote on weekends, Saturdays and Sundays. Again, some states have gone to that measures, but others have taken those away, and in some states they're non-existent. And each state would be required to ensure that early voting polling places were within walking distance, and that they would be accessible to public transportation. They would be accessible in rural areas and also located on college campuses. And so as we think about what is going on with these two pieces of legislation that are stalled at the federal level, individuals are trying to advocate to make sure that these two bills are passed. One of the other measures is mail-in voting. Many states have started a process of mail-in voting. However, this bill, if passed, would create national standards that would actually permit no excuse voting by mail. So individuals would not have to have a reason not to vote early. They just could vote early because that's what they choose to do. And states will be required to permit voters to apply for absentee ballots, not in person, but online. And they would make sure that all states got rid of having individuals to have ballots, mail-in ballots notarized. And then they would also have polling places where individuals could actually drop off those ballots before the election to safeguard the fairness of the election process. Also, one of the other pieces in this particular piece of legislation, it would actually require states to get rid of the secure envelope process, and any ballot that was postmarked on election day that arrives within 7 days would need to be counted. And the ballots could not be discarded for minor issues such as failing to use a secure envelope. Election on holidays. The bill would make election days on holidays legal for individuals to make it easy for people who actually work, that they could actually vote on specific holidays. And then voter validation. The bill would permit and promote a national standard for states that have an identification requirement for in-person voting to allow for a wider range of forms of identification and alternatives to individuals using a driver's license. And states that don't impose an identification requirement would not be required to do so. And so many of the measures that are before us or before the Congress today, they're measures that would actually thwart voter suppression. The goal would be to thwart any kind of suppression of the vote, and it would be amending the current voter rights, the Voter Rights Act that we have on the books today. Also, it would crack down on deceptive practices such as intimidation, because in some instances, individuals feel that at the ballot box, they're being intimidated. The bill would prohibit individuals from being harassed at polling places, and it would allow for the prosecution and penalties would increase for intimidating individuals who are at the ballot box, who feel that they have been intimidated because they exercise their right to vote. Also, this legislation would restore voting rights, have a provision for voter right restoration, and the bill will restore the federal voting rights to formerly incarcerated individuals. We know that there are individuals in our country, across the country, that have been incarcerated. Those individuals don't have the right to vote. But if in fact this piece of legislation passed, the bill would restore federal voting rights to individuals who had been formerly incarcerated upon their release, and would establish a bright line standard to replace the confusing patchwork of laws that have been in place back to the days of Jim Crow. And then counting, if you think about the long lines we've seen on the news and in the media, individuals that had been in line for such a long time waiting to vote. The bill would create protections for individuals subjected to excessive lines on voting days. We know that most of those people who are standing in long lines are Black and Latino voters, and it would require states to ensure that lines last no longer than 30 minutes. And it would restrict states from prohibiting individuals from bringing donations of food or water to those individuals who are waiting in line to vote. And then another provision is the private right of action. The bill would create a cause of action that would allow voters to sue when their constitutional rights were infringed upon. One of the other pieces is preventing election sabotage. Voter suppression and extreme gerrymandering are themselves forms of election sabotage, and the authors of this legislation believe that the freedom for individuals to vote should be something that individuals that if elected officials sabotage an election, those individuals should actually the law should be on the side of making sure that voter suppression does not happen and that gerrymandering is ended. Restrictions on the removal of elected officials. The bill would increase the protection for local election judges. Those individuals who are local election judges would have protections under this law. The bill would allow officials administering the elections at the federal law to bring lawsuits against individuals if they're negligent in their responsibilities in terms of doing their jobs. It would enhance protections at the ballot box on records. And then it would actually the bill would allow for a cause of action on the infringement of the rights to vote, and it would allow individuals to bring a lawsuit or a challenge if they felt their individual rights were infringed upon at the polling places. And so these pieces of legislation are actually waiting. They have been in the Senate. The House has passed a couple of these measures, and they're stalled in the Senate. And so as we think about voting rights and as we think about how to modernize the election process, this piece of legislation would also, the Freedom Act, would modernize our election system for millions of Americans who vote. And the bill would make automatic voter registration in all states, including the District of Columbia, a standardized way to vote. They would also put a provision in place for same-day voter registration. And it would not only would it put it in place, but it would require states to offer same-day voter registration. And we know that happens in 20 states already. But again, these pieces of legislation, these individual pieces that are up for debate now, it would standardize and actually make the system one that would would be in one state in the South, but it would be something that would be across the United States. And it would prevent and safeguard and prevent unlawful and faulty errors, purging of the voter rolls. And it would make sure that if an individual removes a person from the voter rolls, that they actually do that in such a way that does not take away the rights of the individual. And so along with all of this would come some campaign finance reform. And when you think about the amount of money that is spent on campaigns, there are individuals who are disenfranchised that don't have an opportunity to participate in the process simply because they don't have the funds. And so the Freedom Act and the Freedom Act to Vote would actually take a critical step in overhauling the campaign finance system and fixing that system. And the bill would tighten the rules and the unintended rules around super PACs and who gives money and how that money is seen and how that money is given to individuals who are voting. The bill would ensure that the Federal Election Commission would investigate violations of the law and also promote security in the election process. It will require states to conduct transparent post-election audits to make sure that everything was done within the rules and procedures. And the bill would also require states to replace the old and outdated paper system of voting with new systems that would actually be able to record the vote in a more succinct manner, and it will provide grant funding to states to make sure that all of the votes were done in a secure manner. And so even though the Voting Rights Act of 65, again, it was landmark, it was a piece of legislation that was aimed at ending discrimination at the poll. President Johnson, when he signed it into law at that time, he really believed that law would do really 5 basic things. And among those were going back to the Civil War and the 14th and 15th Amendments that were passed after the Civil War in order to protect the voting rights of the newly freed slaves. However, a century after the Civil War ended, we know that African Americans were still being discriminated and that process was still being circumvented. And when we look at Selma, Alabama, and what happened on March 7th, 1965, when a group of African Americans marched in Selma and they protested against voter suppression. And the marchers were attacked by state troopers. We know that was called Bloody Sunday. Again, as we look at the series of things and events that prompted Congress to draw up the Voting Rights Act and for President Johnson to sign that law within 5 days after it was introduced, that was historic. And also the inclusion of other minorities was the third thing. Throughout the act, even though it was directly related to African Americans, other minorities also shared in those provisions. In 1975, the act was amended. Indians and Asian Americans and Alaskan Natives and people of Spanish heritage were also included in the act. There have been many revisions, and there have been 3 significant revisions to the original act. In 1975, the Voting Rights Act was amended to include provisions requiring voting material to be available to minorities and who were eligible to vote, but whose primary language was not English. A second amendment came on board in 1982, providing voting assistance to voters who were blind, disabled, and yes, for those who were illiterate. So there have been changes and revisions to the Voting Rights Act, and all of the things that are on that are sitting in Congress right now, they are very controversial. Section 5 was declared unconstitutional in 2013. Many minorities and support groups voiced their outrage. And meanwhile, a new controversy has arisen around voters and the ID. And there have been many other claims that have been made from individuals who have filed many lawsuits, and advocacy groups have come together to talk about the discrimination at the polling place. And we know that the fight continues to go on today. The bill is stalled in Congress right now. We will look forward to seeing what happens in the days and the weeks ahead. But clearly, if we look at the original intent of the Voting Rights Act and we look at what is on the horizon today, certainly change does not happen overnight. Change often happens incrementally. There are many organizations and groups that are fighting fiercely to protect the right to vote, but also to go back and make sure that landmark legislation that passed in 65 does not go away, that it stays on the minds of those in the legislature, for those in Congress, to make sure that as we move forward, that the rights of individuals, not only of those of African descent, but those of other individuals who are disenfranchised, that their right to vote is preserved. Thank you for your time. And now I will open it up for discussion and question. Thank you very much.
Thank you so much, Dr. Baker. And we do have a few questions for you right away. So one of the first questions is, are there additional items beyond voting attached to the pending voting rights legislation? If so, are these perceived to be major factors that prevent Republicans from supporting the pending voting rights legislation?
There are certainly many individual pieces that are in the voting rights that are in these amendments that don't have to do with voting. One is clearly the issue of gerrymandering and how districts are drawn, districts being drawn, making sure that when we talk about some of the districts look like a salamander in terms of their shape. They're not compact, they're not contiguous. So I think that is one of the things. It's really not about voting, but it's about not allowing legislators to decide who their constituents are, but letting the constituents basically decide based upon who lives in a particular area, as opposed to pulling a community apart when you talk about communities of interest. Another piece that is very controversial is the whole issue of campaign finance reform. It's not about voting, but it is about voting, because when we think about dollars that go into elections, when we think about how campaigns are financed and how much money can be put into a particular area, that's one of the other pieces in the legislation. It's not about voting, but it is about voting, because when you think about trying to run for office, I think that is one of the other pieces that is very controversial. And then there are others that is not about voting, but it is. When you look at ballots, there's always a difference of agreement about sending a ballot through the mail and who fills out that ballot, and whether or not that ballot is filled out by the person who is the receiver of that ballot, and whether or not a ballot gets lost and then a person says their ballot got lost and they try to get another one. So there's a lot of controversy swarming around whether or not there ought to be individuals receiving ballots through the mail, or whether or not individuals should actually go to a place to vote. But we know that long lines persist. And when we think about technology and having technology be a driver, technology has taken care of so many things. When we look at even this meeting today, we're not in person, but all of us together in one place, using technology to be a driver instead of some of the paper ballots and some of the other things that we're doing in many of the counties. I think technology is another piece. Well, it is about voting, but it is about putting together a system that is comprehensive for individuals to be able to exercise their right to vote.
All right, thank you. A second question is really the combination of two, both about term limits. The first question asks simply, what is your opinion on term limits? And the other one asks, do you think term limits are a hindrance to any type of legislation or to those who want to suppress particular populations from voting?
Term limits are people vote with their feet oftentimes, and I and as we look at states that have implemented term limits, one of the arguments in opposition to term limits is the lobbyists and the staffers actually become the individuals who have all the power because they are the people that are there. And so as we look at term limits, we have to think about those individuals and the knowledge that goes away with term limits. And I think the best form of term limits are voters, individuals getting out, exercising their right to vote. If a legislator is not doing, or a member of Congress is not doing what you want to do, we have the right today to limit their terms. But we also have states like Missouri that have term limits in the state of Missouri. And what you find oftentimes is in those states, you have an individual who will run for the House. They will exceed their terms in the House. They will then run for the Senate. They will exceed their times in the Senate. And then so it's a musical chair. And the person that's left there in the office are those long-term staffers. And those staffers become the individuals who have the institutional knowledge. They are the individuals who oftentimes end up having the power. And one form of term limit, and when we think about the state of Illinois, we had the longest serving Speaker of the House. And some people talk about term limits, maybe not for the members themselves. Some have argued that maybe there ought to be term limits on leadership, that if you have a situation where at least you allow the constituents, the voter, the electorate to be able to vote in who they want to vote in, but then you have this group of individuals in the House and in the Senate, and instead of allowing a Speaker of the House or a President of the Senate to serve an indeterminate length of time, some would argue maybe that is one way of limiting the power or sharing the power, is if you limit the time in leadership.
All right, thank you again. Another question: wasn't Election Day a holiday in Illinois in the 70s? Or was it a local issue? Because I always remember being off from school that day. If it was a holiday, when did it change, or why?
And in terms of how, again, the bill that's before the Congress now, the bill would make Election Day a legal holiday in every state. So even the one of the things that the new legislation that is pending does is it makes all of many of the provisions that we're leaving to the states. It actually makes those provisions something that has to happen in every state. And so right now what we have is we have a quilt, we have a patchwork. Depending upon where you live is how you vote. There are individuals, we live so close to state lines, individuals that live in Missouri and Illinois, people that live in Kentucky and Illinois. We have all these bordering states, but depending upon what state you live in, your state legislature can actually pass a bill to allow something that another state does not allow. And one of those things is Election Day being a holiday. And that is one of the pieces that the proponents of the two pieces of legislation that are before the Congress now would like. They would like to see, just for instance, mail-in votings. If you think about a state like Colorado, in Colorado, everybody gets a ballot in the mail. And so when you look at that, there are other states that don't do that. And so the legislation that's before the Congress now would actually standardize and make all of those provisions, actually, including early vote, it would make all those provisions the same, no matter what state you live in.
Mm-hmm. Okay. Well, on that about holiday for school children, in our local area, often the schools are the voting polls. So that could have had something to do with there being no school, because you had so many other people in the school buildings those days. So, okay, one other thing that someone wanted to ask: the definition of disenfranchisement. How do you define disenfranchisement?
Well, okay. Disenfranchisement means many things to many different people, but I think those individuals that have been left out of the voting process. If you think about when you had those individuals under Jim Crow, for instance, and when you think about that, maybe it could be, some people define it as the descendants of slaves. Some people define it as low income. Some people define it as those individuals that live below a certain poverty level. And so disenfranchisement could mean different things to different individuals, but it clearly in this instance really means those individuals who have had a history of not being able to be a part of the system.
All right. Well, Dr. Baker, I think we've taxed you there with asking our questions. We seem to have exhausted what we have for questions. There was one in there where someone was asking about state crimes versus, I think it was meant to be state crimes versus federal crimes, and whether a person's voting rights get restored. But it had state both places, and I don't know how to sort that. Is there anything you can say?
Well, I think what this particular piece of legislation is trying to do is, no matter if it was a state crime or a federal crime, they want it to be the same across all jurisdictions. So an individual that had been incarcerated at the state level or the federal level, they want those individuals to have the right to have on the day that they get at the day that they have served their time and they leave the criminal justice system, allowing those individuals to have the right to vote. And that is one of the fun, when you think about Jim Crow and things that happened before Reconstruction, that was one of the ways that you could get a person out of the voting process. If a person had a background, or many people were jailed unfairly during that time. They were jailed unfairly. And the result of that incarceration was the fact that they lost their ability. They lost their ability to vote. They lost their ability to be a part of the process.
Okay. There is another question that has come in now. Someone is making sure we didn't forget this point. It says, how can we realistically expect the people who benefit from the current campaign fund system to vote to change the system?
That is one that will take a lot of courage and that will take a lot of determination, because it's interesting in the state of Illinois, the whole process of, if there is a tie, you pull a person's name out of a hat, redoing the system of how we elect how we do our redistricting. The pendulum swings back and forth depending upon who's in power. So that is one of those things that it will have to take. It will be a bold step a bold push from the constituents to say enough is enough. We're going to have to change the system. There have been moves to put things on the ballot on many occasions to change that, and it has not changed. And some of it is because those individuals in power, it's hard to give up that power. And the other piece, Ella, is the whole piece about education. The NAACP and other organizations banding together, making sure that individuals understand the power of the vote, understanding that that there is no reason that only 60% of the population actually votes. And the notion of those individuals and how you vote, and the fact that there are many individuals that don't vote in primary elections, and we have to ask ourselves the question, why do primary voters stay away from the polling booth? Well, many of them stay because they would like to have a closed primary where they don't have to declare Democrat versus Republican. And so as long as we have people that shy away from the vote, we have many more people that will turn out for a general election than a primary election. Well, you've just given away, as a voter, you've given away your power, because you didn't decide who would be at the top of either ticket. And there are those individuals who say they vote in a general election because it gives them the ability to be able to split their vote. They can vote if they're independent, they can vote for a Democrat, a Republican, they can vote up and down the ticket, but for either party. But in that primary election, you have to pull in the state of Illinois, and in most states, you have to pull A or B. You cannot, there is not an in between. And so when we look at that piece, the whole notion around voter education, we have to do and continue to do the work that your organization and others are doing around voter education, getting individuals to understand the power of the vote.
All right. Okay, another particular question has come in, and it's about voting without an ID. It says, does the John Lewis Voting Rights Act of 21 allow voting without an ID?
It does, and it would promote a national standard for voter identification. And so right now there's a wide range of things that individuals have to do to vote. This looks at such things as maybe a fingerprint to vote. Mm-hmm. as a part of identification. It could be an optic identification. So I think they talk about the science and trying to move forward and start using more things in technology, bringing technology to bear. And it will be a costly proposition. It's not something that comes cheap. And so, yes, it does talk about promoting a national standard for identification when people vote in person, and being able to maybe use electronic forms of verification. So if you say you have a driver's license, perhaps there might be a way where they could connect with the Secretary of State's office and pull up your information. You might not have it with you on your person, but being able to pull that up. And so they have looked at, as they think about and talk about how to make sure that they are getting valid identification, and not just give me your driver's license or your state ID or you can't vote, using some other means of doing that, and technology being one of the drivers.
All right. Again, Dr. Baker, thank you so much for being responsive to all the questions. I think Dr. Flowers is probably going to want to give closing remarks. And there she is.
Again, thank you so much, Dr. Baker, for spending this evening with us, as well as to everyone in attendance on the Zoom and on Facebook. We look forward to seeing you all again next month on the third Tuesday of April, which will be April 19th. We'll be looking at campaign finance and the influence that big business has on our election. So April 19th, 6 o'clock, we'll see you all then. Thanks everyone for coming. Good night.
Thank you.
Thank you.